if you are a carrier that has drivers that struggle with English language proficiency or that are operating on non-domiciled CDLs, you run pretty serious risk, not only on the regulatory side of things. The highway accident exposure that this is creating for you is noteworthy.
All right, so I'm talking to Brandon Wiseman. He's a transportation lawyer and DOT guru, owner and president of TruckSafe Consulting, about the top trends and actions we've seen from the DOT and what we might expect in 2026. And wow, there's a lot we could talk about. You said, I think in your blog, you called this a turbulent, was it regulatory turbulence? Let's kind of big picture there and talk about that regulatory turbulence.
Yeah, it's been one of the busier years for sure from a regulatory perspective in recent memory. And even just within the last, 6 months, we've seen the FMCSA and the US DOT more broadly implement several new regulatory/enforcement initiatives that have had a big impact and will continue to have a big impact on fleets and their drivers into 2026. So happy to break those down.
What are, you think, the most significant that we've seen?
Well, far and away, the most significant are the ones that have come to light within the last few months here, namely the English Language Proficiency enhanced enforcement that we saw starting in late June of 2025. And then kind of a related issue, which is the crackdown on non-domiciled CDLs and the new, more stringent requirements to obtain those CDLs. So English language proficiency, for those not familiar with it, this is something that's been baked into the federal safety regulations for decades at this point. It's not a new requirement. And it requires basically that all regulated truck drivers, truck and bus drivers be able to read and speak the English language sufficiently enough to be able to converse with law enforcement, read road signs, and that type of stuff. The thing that has changed, though, is how stringently that requirement is enforced. And so over the last few decades, we've seen some ebbs and flows in terms of how strictly it's enforced. And for the last 10 years or so leading up to 2025, even though it was on the books, English language proficiency was not considered what's called an out-of-service violation, meaning that even if drivers were tagged with that violation during a roadside inspection, they were permitted to continue operating their trucks. That changed in, like I said, late June of 2025. President Trump signed an executive order that was unique to trucking, which is noteworthy in and of itself, that essentially mandated that the US DOT and the FMCSA, by extension, crack down on this issue specifically and start rendering these violations out of service again, which they had been in the past, just not in the recent past. Right. And so starting in late June, these violations have been out of service in nature, meaning drivers are physically stopped from continuing to operate unless and until they become proficient in English, whatever that means. And so over the course of the last few months here, we've seen over 7,000 drivers, I think, placed out of service for English language proficiency. And so big issue.
That's gotten a lot of coverage, even the national media, and been a lot of attention to it.
Very political issue, politically charged, to say the least, along with the next one, which is the non-domiciled CDL issue, also kind of stemming from the same executive order from President Trump. So this is coming from the top down. And it's a look at these non-domiciled CDLs. We don't have enough time to get into the nitty-gritty of what those are. Suffice it to say, it's a special type of commercial driver's license that's issued predominantly to foreign nationals who are operating in the U.S. And they have been issued by the states for a few years now. And the US DOT had initiated earlier kind of an audit of the state's issuance of these types of non-domiciled CDLs, looking to see who's getting them, how long are they getting them for, because the FMCSA has rules that kind of, guardrails up against who's eligible for these types of licenses and that type of stuff. And according to the USDOT, their audit of this program revealed systemic non-compliance with the agency's rules on who's eligible to get these types of licenses, which, according to it, has led to some pretty serious consequences, including several high-profile accidents involving non-domiciled CDL holders that the USDOT has referenced in its press conferences. And so all of this led up to FMCSA and USDOT promulgating what's called an interim final rule, an IFR. It's a kind of a short circuit to the normal rulemaking process, where it's sort of like an emergency rule that took effect immediately upon publication and really cracked down on who's eligible to get these types of licenses going forward, and how long they're able to hold them is essentially what it did. So it really significantly cut down on who's going to be able to hold these going forward. And, suffice it to say, it drew a lot of criticism in and of itself, another very politically charged issue. FMCSA ends up getting taken to court. Unsurprisingly, they were sued for whether they followed the right procedures to get this rule passed. And that ended up with a federal court, the D.C. Circuit Court of Appeals, issuing a temporary stay of this rule. So as we're talking today, that rule is not in effect because of the court stay. Right. And so, just reading the tea leaves here, and I think the FMCSA has actually agreed to this, that case is going to be held in abeyance, meaning not progress any further while the FMCSA goes back and reviews all of the comments that were submitted. Over 8,000 comments, I think, submitted in the context of that IFR, and then decides how it's going to handle this issue going forward. And whether that means, they come and do the full rulemaking process, that's probably what will happen. But that's what we'll be looking out for in 2026.
One of the recent changes that really kind of caught my eye, because we've talked about this before, is the electronic logging devices. Basically, FMCSA is going to tighten oversight over what ELD providers get on the approved list. Kind of give us a quick overview of that.
Yeah, so folks are generally familiar with electronic logging devices. They have been mandated in the United States for most regulated drivers since 2019. The rulemaking process for that started many years before 2019, but in 2019, that's when most regulated drivers are supposed to be using those devices to keep track of their hours of service compliance, as opposed to paper logs, which we had historically been using to do that. And the whole idea was to cut down on the amount of fraud with, drivers and carriers and others kind of fudging their logs and trying to gain more time in their day, which in turn leads to, fatigue. And then you have tired drivers out there operating really heavy trucks and buses. Not a good idea. It could have gone one of two ways when it came to these devices. Obviously, the FMCSA itself is not the one manufacturing these devices, so it opens it up to the market to create these devices. The FMCSA, for its part, sets up what it calls technical specifications for these devices. The regulations spell out exactly what type of functionality has to be baked into these devices and what rules it has to help drivers comply with, and what things can be done with the devices and what things can't be done. And that's, that goes right back into the fraud. We don't want devices that are easily manipulatable, or else you end up right back in the same place you were with paper logs.
Right.
And so, like I said, it could have gone one of two ways. Either the FMCSA could have said, we've got these technical specifications, we're going to allow third parties to manufacture these devices, but we, FMCSA, are going to certify the device's compliance with these technical specifications before we allow them to be sold. So that's one way they could have gone. They chose not to go that way, it turns out. That's the way Canada went with its ELD mandate. The way that the FMCSA decided to go was with what's called a self-certification process, where the manufacturers of these devices themselves have to certify that their devices meet the technical specifications before they're allowed to be placed on the list of self-certified devices. Of course, you could see the problem with this, right? Because it's like a trust me type deal. And as we've seen over the last several years, it turns out that several devices, even though they have been self-certified as compliant, are not compliant, and they get removed from the list by FMCSA following an investigation. So long story short here, FMCSA is recognizing that there are problems with this approach. I don't think it was any secret. They knew this
No.
leading up to it, but they have recently come out with a notice that says they are going to crack down on the devices that they allow to be placed on that self-certification list to begin with. Still going to be a self-certification process, but there's going to be some additional vetting that goes on according to the notice. We don't have a whole lot of details yet about what all that entails, but I think the important point for now is that this is not a government certified program that we're moving to. We're not going towards a system like Canada's. It's still going to be self-certification, but the agency is going to play a more active role in vetting the devices before it lets them on the device or lets them on the list. Hopefully that will then kind of prevent bad actors from getting their devices on the list, especially what we call chameleon devices, where they're on the list, they get taken off for noncompliance, and then they just rebrand under a new name and they put it right back up on the list. That's been a big problem. So we'll see.
I'd heard recently from a trucking company owner that I've known for a while. He's been trying to bring a lot of attention to this broad issue with ELDs and carriers basically editing the logs and adding like a fake co-driver. Now, there's perfectly legal and allowed reasons for making edits, but from what I understand, these, I guess, unscrupulous carriers and ELD makers are going way beyond what the rules allowed for edits. Like, initially it's like, okay, your driver forgot to log in or log out, right?
Yeah.
And so the carrier edits it, and there was had to be on a paper trail, so to speak. Not paper, but...
Yeah, I mean, it's the nature of laws, right? I mean, for as long as we've been a country of laws, we've had folks that have found ways around those laws. That's just it's the reality of things, and it's the case with ELDs as well. We had hoped that ELDs would cut down on the amount of fraud, and maybe it has to some extent, but it has created its own new problems. It's not something that you can avoid, at least from my perspective. And so it's the real question is recognizing that there are going to be bad actors who try and find ways to get around the laws that we set up. How can we best implement systems that safeguard against that to the greatest extent possible? And, like I said, the rules already have some of those safeguards in place, the technical specifications. You're right. They do allow editing logs in certain situations, but there are limits to, properly editing logs. And to the extent you have bad actors who are editing logs that go beyond what the regulations allow, in most cases, that's going to be easily recognizable by law enforcement in a roadside inspection or certainly in an audit. There's going to be a trail, as you say, that's going to expose that fraudulent activity, and that's going to play out badly for that motor carrier and those drivers. And we see this all the time with log falsification violations being one of the top violations discovered during roadside inspections and in audits. And those routinely get carriers shut down and drivers shut down on the road.
There's only so much that the FMCSA can do in carrier audits. It's a big problem for a long time.
There is. And they're just going to have, for their part, they're just going to have to keep up with, there's no shortage of creativity as the bad actors learn. Trying to figure out new ways to get around it. So FMCSA is just going to have to keep up with that, keep on top of that, and start putting patches in place to address these issues as they come up. That's just the nature of lawmaking, unfortunately.
That's another recent rule change or announcement that we've gotten dealing again with drivers is the entry-level driver training requirements, and again going to a list of certified providers, so to speak, or not certified. Can't remember how many, something like 3,000 or 4,000 schools. They've said nope, you don't. You're off the list. Yeah. Talk a little bit about that.
Yeah, FMCSA likes its self-certification list, clearly, because this is another one, a list of self-certified training providers. This is a program that went into place in 2021, 2022, mandated entry-level driver training for folks that are seeking a CDL for the first time or certain upgrades to their existing CDLs, Class B to Class A, for example, have to go through this mandatory training. I mean, it was clearly a step in the right direction. We want to mandate a certain curriculum that these drivers go through to make sure that they have a baseline foundational knowledge of the things that the DOT thinks are important before they get their licenses. So that from that perspective, it makes sense. But then things start to fall apart pretty quickly because, now the DOT, similar to what it did with ELDs, it leaves it up to the market to come up with the folks that are going to be providing that training. And they don't have to be certified by the DOT or anything like that. They are just self-certifying that their training program meets the minimum requirements that are set out in the regulations. And those minimum requirements, the requirements set out the base curriculum that has to be followed, the topics that have to be discussed. But beyond that, it doesn't set things that you might expect to see in there, like a minimum number of hours for the training or anything like that. That didn't make it into the final rule.
Right. Yeah, I remember that was kind of controversial.
It was very controversial. And so it leaves it up to the training providers largely to develop whatever type of program they see fit, as long as they hit on all of those required topic areas. The problem is you end up with some training providers that have been legitimate training providers for years that have a proven method that ends up with, hours and hours of training, detailed training on these topics for drivers. But then on the other end of the spectrum, you end up with training providers that are just doing the bare minimum. They are covering the topics, but we're talking, a day or two is worth of training, and then they certify that the driver has successfully completed it. So FMCSA has announced that they are also cracking down on this. As you said, they have announced that they've already removed 3,000 training providers from the list, finding that they are non-compliant. I don't know the details of their non-compliance, but
they haven't released any, I don't think.
And then 4,000 more are in the crosshairs. And so a significant percentage, I think there are around, I can't remember what the number is, maybe like 16,000 or so training providers on the registry, something to that effect. Or actually, it may be more than that.
Yeah, it's a lot, a big hunk of the number of schools that.
It was double-digit percentages of schools removed from the training provider registry. Does that really address the underlying issue here? Probably not. Again, it's a step in the right direction to get bad actors out of the industry, but it doesn't really, in my opinion, get to the root of the problem, which is we need a more thorough framework through which we are going to require these training providers to provide to their students, probably, is one thing that we need. And we probably need some more oversight before we allow any of these training providers on the registry, frankly. But that's just my 2 cents.
Is there sort of a theme that we're seeing with all these regulatory and other actions from DOT and FMCSA?
Yeah, the theme is enforcement, a crackdown on enforcement. So for many years, you could argue that we've had fairly lax enforcement on many of these issues. And that's been true under both Republican and Democratic administrations. So I'm not blaming one or the other. But one can make an argument that that has been the case. And so what we have seen more than anything else, I would characterize as a crackdown on enforcement. We're starting to see some of the rules that have been on the books for years enforced more strictly than they have been over the last several years. And, it's causing mixed reactions. I mean, largely from what I can glean from trucking media and my industry contacts, most are in favor of a lot of these changes, from what I can tell.
Another thing I've thought was interesting, and that kind of ties into this administration's approach in general, is that they seem to be trying to take actions to address the sometimes frustratingly long process of actually making new regulations. Like you and I talked 3 years ago about, they basically floated a proposal for changes to ELDs, which included, should we make changes to, the registration process? Should we be certified? And people get, okay, well, you did this. What happened to it?
Yeah.
And that's always been the case.
Yeah, I think there's a few things going on there that are worth discussing. One is just the normal rulemaking process that any federal agency has to go through, which is dictated by the Administrative Procedures Act, the APA. It's an act of Congress that dictates the process, the normal process that agencies have to follow. Nothing the agencies can really do about that. They have to follow the rules in order to pass a law. And, it requires them to study the issue, to, publish a proposed rule, then open it up for public comment to weigh in, and then to consider the comments, and then ultimately move forward with a final rule that then takes effect at a date later in the future. That necessarily takes some time in and of itself to go through that process. So to some extent, it's beyond their control. But to your point, I don't think you can blame some of the stalling that we've seen in a lot of these areas just on the rulemaking process itself, because we have seen issues like, changes to the safety rating process, changes to the safety measurement system, changes to the data queue system, these things that the agency proposed several years ago at this point that have still not taken effect. And what's the reason for that? It's not just the rulemaking process itself. Clearly, there's something else going on, and the something else that's going on is just the politics of it. We had an administration change. We've got a new administrator. Yep. We've got a new Secretary of Transportation. All of them have their own priorities that they are looking at, and some of the priorities of the last administration may not be the priorities of this administration. And so you get them, coming off of some of the previous proposals and, pushing them further down on the priority list. And so that's just the nature of, federal agencies. So I think that's part of it, in addition to the rulemaking process. And to your point, we did see FMCSA take action, namely in the non-domiciled CDL arena, to bypass the normal rulemaking process in a way that made something take effect immediately. And it blew back in their face, right? Because now they are in a federal lawsuit, having to defend themselves in a federal lawsuit. The federal court has stayed that, saying you didn't follow the normal process. Mm-hmm. And so it's kind of damned if you do, damned if you don't. But that's where we're at.
And they're doing these things like with enforcement of, the regulation itself hasn't changed, but maybe the interpretation or the enforcement of it is being changed without the underlying regulation being changed.
That's right.
So what do you see looking ahead into 2026? What might we expect?
Well, some of these things that we've already talked about are going to obviously continue to bubble up in 2026. They're going to continue to be an issue, including English Language Proficiency and non-domiciled CDLs. Aside from those two things, a little hard to tell. FMCSA certainly publishes its regulatory agenda every year, so we kind of have a sense of what may be coming up. Some of the things I'm tracking, I've already mentioned a couple of them. Those changes to the safety measurement system, I would have expected those to already have gone into effect.
Yeah,
but
we talked about those a few years ago, too.
Yeah. And so those, I would have to guess, I've been saying this for the last 3 years, but I would think that those would be coming into effect, along with potential rulemaking on the safety rating process, the 3-tier rating system that we have now for carriers. I think we have an advance notice of proposed rulemaking on changes to that system, so it wouldn't surprise me if we progress to a notice of proposed rulemaking in 2026. And then, just potential outliers here. I have no idea if these are going to move forward, but I would think we're getting to a point where we have to come up with some rules on autonomous trucks. We are currently, the technology is obviously progressing very quickly in that arena. I know you guys have reported on it, and, we've got fully autonomous trucks operating in certain parts of the country, at least with safety drivers for now, but seems like they're ready to roll. And right now we have no regulations on the books whatsoever governing the operation of autonomous trucks in the country. And so
state.
Yeah, state by state.
What regulations there are.
Yeah, kind of behind the 8 ball here. So FMCSA and NHTSA, for their part, have started to think about this. They haven't come out with any formal rules yet, but I have to imagine that is going to be coming in the near future, just to try and get ahead of the issue before it really blows up into something bigger. So those are kind of the things I'm watching for in 2026.
I don't know that's also something that the DOT has, Secretary Duffy has specifically said that they are working to get those rules. But the technology changes so fast. It can be a challenge.
Yeah, for sure. And the minute they, again, it takes time to pass a regulation. So by the time they pass a regulation, the technology has probably already leapfrogged.
We've seen that happen in the past.
Yeah. So, but we got to get some kind of framework on the books here in the near future. So I imagine that we will see that. So,
All right.
And maybe the DOT will continue to weigh in on what we have to wear to the airports when we fly. Seems to be their focus lately.
Yeah. So if I'm a motor carrier, what should I be doing?
Yeah, on the ELP and the non-domiciled CDL fronts in particular, those, in my view, are the things you need to be focusing on immediately because they are tremendous sources of exposure for you.
Yeah.
If you are a carrier that has drivers that struggle with English language proficiency or that are operating on non-domiciled CDLs, you run pretty serious risk, not only on the regulatory side of things. If they get stopped and placed out of service, that's a problem for you and your customers, obviously. Or if they're on a non-domiciled CDL and there's the potential that it gets yanked from them, here in the near future, that's going to also cause you regulatory problems. But putting those aside, the highway accident exposure that this is creating for you is noteworthy. You have to take notice of this because I just look at some of those high-profile cases that we saw in the news, the Florida U-turn crash, for example, and the tremendous amount of publicity that got. If you're not put to trial for those issues in a court of law, you're going to be put in on trial in the public media, and many carriers can't survive that type of thing. So just take a step back, at least take a look at your records and see how many of these folks may be operating for you, and then start to put some real thought to next steps and what you need to do to get control of the issues. Maybe on the English language proficiency issue, it's getting your drivers some additional training if you're going to keep them around, some substantive English language training to avoid the issue. And then on the non-domiciled CDL issue, not a whole lot that you could do. Your hands are going to be kind of tied by wherever that rule ends up. But those are significant issues that I think you need to get your arms around.
Well, thanks, Brandon. Always good to talk to you. You always explain things in plain English, which if you start reading the Federal Register, that kind of translation is really helpful.